Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya. Uya matinyana. Uya matinyana. Yeah. Uya matinyana. Uya matinyana. Say, I call you Jireh, say, I call you.
It's always a joy coming your way every Saturday afternoon with the community and the law. Today is not an exception. So we are ready to meet you in the community, and we're bringing you this live on BWTV, and we're doing this together with BWF Solicitors. My name is Oreku Frimpong. Joint ownership of property. In the Akan language, they say something like, "Awami any awayen and your pet." For me alone and for us together are not the same. But when we are able to put something together and we want to leave that legacy, what are the implications? Joint ownership of property, implications for our will, is our topic for discussion on the community and the law this afternoon, brought to you by BWF Solicitors. Let's get into it together.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422780. It's the community and the law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
We are live and we are with you in the community on a Saturday afternoon, very lively and lovely as you want to have it. My name is Oriku Frimpon, and good afternoon to you once again, and welcome to another edition of the community and the law. I'm doing this courtesy BWF Solicitors, and we are live on Facebook at BWF Solicitors, BWTV, on YouTube at BWF Solicitors and BWTV. This afternoon, we are privileged to have another of the very knowledgeable and astute lawyers from the fold of BWF Solicitors to be with us to help us in our discussion. I'm happy to let you know that we have Lawyer Charles Asma with us, and he is going to be a resource person, a guest, and a friend in the law. Lawyer, good afternoon.
Good afternoon, Ragaku.
Thank you very much for joining us, and thank you for allowing us to take part of your day. At least these 2 hours would have been precious doing other things, family-wise maybe, but you are spending that with us, and on behalf of our listeners, our viewers, our clients, and friends and family, we are grateful and we thank you.
Thank you, Ragaku.
Right. Well, folks, we will be looking at the topic, very sensitive one. You know what? Life starts and ends. So whatever it is that we have to do, we have to plan how we come in, which obviously some of our parents do for us, and how we go out. In between, the things we do and the legacy we leave behind is pretty important. Your will. You come into this world and you form associations, and we would want to find out what you do during those associations, partnership, marriage, here and there. When you do properties or you acquire properties together, so to speak, what are the implications for what you leave behind in the form of will? Who has what and who can bequeath what? These I'll be having those questions posed to Lawyer Charles Asma to help us with that. So if you're ready, I would want you to sit back, relax, and enjoy. But first of all, let's do some housekeeping. When you log on, please announce your presence, share the page, like the page, and also subscribe to the channels so that when we put up any content, you will be notified and you not miss out. Because this afternoon is going to be another special one. So those of you who have joined us, I want to say thank you very much, and I wish that you have the chance and the time to stay with us. When the lines are active, you'll be able to call us on 0208 493 7345, or you can send a text or WhatsApp message to 07399 208 468. 07399 208 468. So let's get ready to get into this together. I will want you to have some information really quick. First of all, I'm coming in-house, and as I said, I was doing the in-house housekeeping. When you come to BWF Solicitors, you are met with a smile. You are met by the warmth of the place. And one of the very first persons you see when you visit BWF Solicitors is Madam Sandra Fraser. And for the month of May 2025, BWF Solicitors have given her the prize and the award of Employee of the Month. Congratulations to you, Sandy. Thank you very much for doing what you do. And if you would observe, those of you who have always been with us on the program, you realize that when we start on the comment section, either on Facebook or YouTube, you see her giving you directions, asking you to share and like the page, and also giving you contact details as well. So, Sandra, thank you so very much. We appreciate you, and being the Employee of the Month shows that your work is not gone unnoticed. You are recognized, and we say congratulations. Keep doing what you're doing. Thank you very much. Well done. Well, somebody is also very happy with BWF Solicitors, and he has come in to say that my journey with BWF Solicitors has been incredibly amazing. I'd like to say a very big thank you to the entire team, most especially to lawyer Annie Akofio-Sowa for her professionalism on my case. The refusals, appeals, she conquered everything. I personally recommend her to all for immigration challenges. Such a professional. Annie, thank you very much for putting a smile on the face of one of our very own, and also giving them the confidence that when it comes to BWF Solicitors, we do it well. Thank you very much. She's not here, but I will give the chance to Lawyer Charles Asma to kind of respond to me for the very wonderful, warm words that she has put out to the firm.
Thank you very much, Nee. Nee and many others are echoing the things that many of the community members are appreciating about what BWF Solicitors stand for. We believe that everybody's case is unique, and we tailor their case in a way that achieves an aim and brings smiles. And so one of them is what we are witnessing. And on this occasion, Nee is saying that your go-to place is BWF Solicitors. So well done to my colleague, Annie, and of course the entire team. And Nee has said it all.
Nee has said it all, and there's more to say. If you have had that experience, please let others know. Any feedback you have as well, please let us know, because we need that to help us improve upon the performances we put out. So you can contact us on this number 0208 7340. And if you're in Ghana, there's an office in Ghana where you can go in there and experience the same as we do here in the UK. 055 589 5959. 055 589 or you can send us an email, admin@bwfsolicitors.com. You can visit us on all social media platforms at BWF Solicitors. Thank you very much, Lawyer Thank, for responding to that. Now let's look at a bit of a piece of information, so to speak, to help you understand the things as they unfold here in the UK. Under paragraph ST 39.1 and ST 39.3A and BI or II of appendix student to the immigration rules, the long quotes there. A dependent partner will be granted permission which ends on the same date as the student's permission. The dependent will have no access to public funds, and where the visa was granted for a period of less than 9 months or the student is studying a course below degree level, there will be no right to work. Working in breach of your leave condition as a student dependent is an immigration offense. Paragraphs ST 31, 39.1, and 39.3 of Appendix Student to the Immigration Rules, Section 24 of the Immigration Act of 1971, as amended. When lawyers say as amended, it means that there was one before and there have been some changes, updates here and there. So let me go over to Lawyer Charles Asma again, and we delve deep into this one and what it really means. Lawyer.
Thank you very much, viewers and listeners. So the nugget for today is to do with students and dependents. So we have the appendix student, which looks at the right of the student partner.
Mm-hmm.
So if we look at paragraph 31.1b, it deals with the duration of the course. And normally somebody will be admitted for a postgraduate course. Some people are admitted for undergraduate course. Some people are admitted for short courses. So B 31.1b says that once you are admitted for a postgraduate course and you are offered a period or granted a period, or another, you are studying for 9 months or more. So normally the master courses are for 1 year, so 9 months or more. Now, once you qualify to bring your dependent, what you have is what your dependent also get. So we look at paragraph ST 39 as well, also looking at the right of that partner. So if you are granted 1 year because your partner is studying a full-time course and the partner was granted 9 months or more based on the course they are studying, which is a full-time course, then you, the dependent, will have the right to study, to have the right to work. Of course, you are living with your dependent, but you have the right to work. In this case, if you have the right to work, you can work. What if you don't have the right to work because your main dependent, your partner, the main student, doesn't have, it's not studying for 9 months plus or doing a short course, then the restrictions will affect you. So in this case where the person has been admitted to study 9 months or more course, postgraduate level, full-time, during term time, the person cannot work more than 20 hours, but the dependent can work, because the dependent is not restricted. So we are looking at people who can have restriction not to work and those who have the restriction to have no restriction to work. And the nugget is saying it clearly that where you have restrictions not to work and you work, then you'll be in breach of your immigration conditions. where there's no restriction because the course of your husband or wife, the main applicant or student, is postgraduate level more than 9 months, or at least 9 months, and is full time, then you, the dependent, should not have restrictions. So where it is mixed up or it is perceived to be that you have restriction not to work and you are, for example, told that you have offended and it turns out that no, that is not the case, then obviously you have the right to challenge that decision. So the most important thing is that everybody looks at their visa grant, the period, the admission they have, the study, whether it's full time, whether it's short term, and so on and so forth, because that will affect the dependent as well.
So in this case, if there's a restriction, how would the applicant, would the dependent of the student, for instance, know that there's a restriction? Would that be stated in their letter, on their card, on their, well, obviously cards are no more in use, but how would they know? How would it be stated and put out to them?
So the decision letter will tell the specific conditions the student has. So in the decision letter, the student will be told, for example, that you cannot work more than 20 hours during school term or university term. You have to be studying. And so if you work more than 20 hours, then you'll be in breach. If you are doing a short-term course, you have certain conditions attached as well. The same will apply to the dependent. So it's always important to look at the conditions of the visa granted from the visa decision letter.
Well, as I said, you would want to know a lot more. This is a situation that's more of a warning to people that if you have restrictions on your visa, please do not go against them because then you are in breach of the immigration rules. If you want further details, yes, I've always advised that you talk to the set of lawyers who know what they are doing, and I recommend that you do that with BWF Solicitors. Call them on 0208 493 7340, 0208 493 7340, or in Ghana 055 589 5959. In all emergency situations, call 077 127 61884, 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. Let's say thank you to that, and just remember again, under paragraph ST 39.1 and ST 39.3A and B, I or II of appendix to them to the immigration rules, a dependent partner will be granted permission which ends on the same date as the student's permission. The dependent will have no access to public funds. And where the visa was granted for a period of less than 9 months, or the student is studying a course below degree level, there will be no right to work. Working in breach of your leave condition as a student dependent is an immigration offense. Please take note of that. And this is brought to you by BWF Solicitors, a trusted partners when it comes to the law.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, we're still live on BWTV and is brought to you by BWF Solicitors, our trusted partners when it comes to the law. Located on the 4th floor, Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. Call them Monday to Friday between 9:30 and 6 p.m. on 0208 493 7340, 0208 493 7340. Well, just before we went on that break, I gave you the nugget, and there's a scenario around it that I want you to consider. That's what we do when it comes to our quiz. And I would want us to give our friend Grace in this scenario a piece of advice. Grace was granted leave to enter the UK as Johnson's dependent from the 30th of September 2024 to the 31st of July 2025. Johnson, a student, has a valid leave from the 2nd of February to the 31st of July 2025. Grace, as we are talking about, arrived in the UK in November 2024. On the 8th of May 2025, she was arrested by the Border Force whilst working in a warehouse. Her leave was cancelled without appeal and was detained for deportation on the 29th of May 2025. Now, before you look at that, look at her situation again. She was granted leave to enter as a dependent of a student from the 30th of September 2024 to the 31st of July 2025. Johnson, who is the main person, has a valid leave from the 2nd of February to the 31st of July 2025. So one significant date is the 31st of July, okay? So take note of that. Grace arrived in November 2024. On 8th May 2025, she was arrested by the Border Force whilst working in a warehouse. Her leave was cancelled without appeal, and she was detained for deportation on the 29th of May 2025. Border Force claims that she breached the visa conditions and committed an offense under Section 24(1) of the Immigration Act of 1971 as amended. Okay, so she's been arrested, her visa is cancelled. What advice can we give her? Would it be one, Grace has no right to remain in the UK because she was caught working in breach of her visa? Would it be that Grace cannot be removed as her spouse still has valid leave in the UK? Or the third one, which is Grace should seek judicial review as she has not breached her visa conditions by working. Think about that. I will be coming to that. But in the meantime, get your text and WhatsApp and all the other bits ready. You can send a WhatsApp to 0739920846. It will be about the topic that we'll be discussing or any other question you want to put in. When the lines are active, you can call us on 0208 493 7345. But let's come to our topic, and we're going to invite lawyer Charles Asma to really lead on that for us. And the topic here is about wills and estates. This update came in, and I want to use this as a prelude to our discussion. It says estates without a will have reached a 5-year high, with a corresponding increase in litigation as families prepare for potential disputes over inheritances. In the past year, the number of estates left behind without a will has risen by more than 50,000. When someone dies without a will and possesses valuable assets, the court typically issues a grant of letters of administration to designate someone to manage the estate. In these cases, the distribution of assets follows strict intestacy rules, which may result in outcomes that the deceased never intended for their legacy. So, my question I'm asking is joint ownership of property. What are the implications for our will? Let's ask, man. When we are baffled, when we have questions, we run to you lawyers. Today we've run to you. Joint ownership of property. The prelude that I read talks about people dying without wills. Maybe we'll look at that as a prelude and look at the conundrum here that somebody has gone into a partnership, a marriage relationship with people, they've acquired property together. The inevitable is we will die. And you lawyers have always advised us to prepare our wills so that the intention we have when it comes to our legacy and what we want to bequeath to people who we leave behind will be one documented and will be according to our wishes. So if I've gone into a relationship, if I've acquired a property jointly with another person, what do I do when I'm preparing my will? I think it's a very broad, multifaceted question, but I know you unpack them so very well and will help us. We have come to your desk. Lawyer, help us.
Thank you very much. So, viewers and listeners, today's conversation is important because a lot of us would want to acquire property anywhere in the world. In acquiring property, because it's difficult, you may join hands with others to do that. These people can be family members, can be friends, can be anybody, can be spouses, can be unmarried partners, can be boyfriends, girlfriends. And so the moment you decide to acquire a property with somebody, that is joint ownership. That means you are not owning it alone. So you team up, you put your resources together, you get a property. So it's going to be under more than one person's name. So it becomes a joint ownership. Now, with joint ownership, normally, as I said, if you are friends, you decide to go this way. And even governments have schemes where people go into joint ownership with a way to help people to climb the property ladder. But there are implications for such joint ownership of properties. And here it cuts across the whole world. So it doesn't really matter where you are in the world. And we're also looking at somebody owning with somebody and the person's life after death. We know that after death, whatever you owned on earth will go to your estate, and that will be distributed if you left instructions. If you left instructions as to how it should be distributed, that is your will. And so your will will specify. So imagine you own a property with somebody and you leave instruction, thinking that that is your asset. You have maybe a percentage, half, 50%. So you indicate in your will, and you are no more. You can't even say that you didn't understand the rules of the ownership arrangement. So those people who are behind thinking that the family member has left them asset, they only find out that due to the nature of the arrangement, that asset cannot go to them. That is one way. The other bit is that you are together, so husband and wife or unmarried partners, and because of the happy days, you own it together, and the relationship breaks down. What happens once the relationship breaks down? You are still owning it together, but what will be the implication? So today we are going to touch base on all these nitty gritties. But you mentioned that people who die without wills and how their properties are treated
Mm-hmm.
in the UK, especially, has risen to a very high level.
Yeah.
In that, once you die without leaving instructions as to how your estate should be managed, it's up to the government to look at how it should be distributed or managed. In this case, it will not follow the will process, but it will follow what we call the intestacy process. So,
Okay.
intestacy means you died without leaving instructions how your assets should be distributed. And so the state will have its own formula to distribute those assets. And it's also possible that such formula will be so narrowed that it may affect anybody to benefit, and so it will go to the state eventually. So it's all important that this topic will give us an understanding. So those people who have already bought properties with friends and families and other people as joint owners will look at what to do to be able to amend the arrangement to benefit them after their death in terms of their successors or the other family members that will be left behind. So we have two key terms. Joint ownership is the main term. And under that umbrella, we are looking at joint tenancy and tenancy in common. Joint tenancy means that you come together to own the property. You have 50% shares or equal share, depending on how many you are. Definitely, if you are four, that would be 25% each.
Mm-hmm.
If you are two, 50%. If you are three, 33.33% in that order. So equal share and joint tenancy. The equal share means that all the rights, all the responsibilities accruing from that property or asset will be for the two of you. Even though you are owning the property, you own it and you enjoy the benefits up to the point of death. Why do we say up to the point of death? The
Yeah.
rules say that if you are joint in ownership or joint in ownership, what we call joint tenancy, it simply means that you are holding hands till death do you part. What it means that once one passes on, if there are two of you, the property will be for the one that is alive or left behind. So if A and B come together to buy a property because they want to get to the property ladder, they put together equal shares in mortgage deposit or percentage shares in mortgage deposit. They will own it together. Depending on, let's take a sample. So two people. And the joint tenancy is between the two of you. If the first person or one of you dies first, the surviving person or owner becomes the 100% owner of the property.
Okay.
And that is called survivorship. Survivorship. So survivorship means that whoever survives last will be the owner. So it becomes a battle of survival, which can be risky depending on who and who are involved. But again, because it's survivorship, once the first person dies, thinking and imagine the person, all of them have put their interest in their will, thinking that they own a property together.
Mhm.
not understanding the implications for their will. So it's between A and B. A owns 50% and B owns 50%.
50%, right.
A has made a will, left a will, and added that property interest to the instructions in the will that this should go to whoever.
Mhm.
B has also done the same thing. Now A dies. We open A's will and we realize that A owned a property at number 4 Kukrentumi Road,
Okay.
postcode indicated.
Mhm.
We go there. Of course, we have to identify the papers. We have identified the papers and we realized that it was joint tenancy arrangement with B, and B was
Okay.
his friend.
Mhm.
So the question is, whoever is named in the will to take that property cannot have that because that property couldn't have been part of A's will because under survivorship, the property can only be fully owned by the surviving party to the ownership arrangement. So B owns the whole property. What it means is that if B dies, B's will be intact because B has left it. So even though B would have left 50%, B will benefit 100% because B died, B was the last to die, so to speak.
But lawyer, I find it a bit baffling, and maybe you would have read that on my face. I go into a joint ownership with a good friend, with a relative, with my partner, and we both agree that I own so much in the property. For instance, I say my partner owns 60%, I own 40%. And then we also have an agreement to say that we can pass on our shares of that property to people we can bequeath or name in our will. Would the law that governs survivorship cancel out the agreement we would have reached before one of them passed on?
Right. So the essence of today's conversation is to bring us to speed with this core understanding. The core understanding, as we know, is that when you go into property ownership together as a family, it
Mhm.
stays with the family, unless there is, for example, separation or divorce. That is
Okay.
when you become separate. But if you are husband and wife or unmarried partners thinking you are going to survive forever or live together and have a family and all that, it
Mhm.
doesn't really matter who dies first.
Okay.
In this case, whether it is joint tenancy or not, it's one family interest.
Okay.
So if it's a family arrangement, people will not have a bother as to who will take after death. But even those who are married, it may happen that there could be divorce and they go their separate ways.
Mhm.
And if they forget that the arrangement was joint tenancy, even though they are gone, once they separate,
Mhm.
they still hold that joint tenancy arrangement.
Yeah.
Imagine the wife living with the children. The wife is looking after the children because the wife lives with the children. The husband is supporting the arrangement and care, maintenance of the children. So the
Mhm.
ex-husband has left the scene. He's living somewhere. But that property is a joint tenancy. And for whatever reason, the woman dies first. What it means is that while the man, the woman's family we think that the woman was living in this property with the children, or the children thought that we are living in this property with our mom, and so the property will be for us to live in once mom is gone. Daddy too, we don't know where he is. We do hear from him, but da 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 da. Only to realize that because mommy is gone and daddy is alive, the property belongs to daddy because it was joint tenancy.
Well, so it presupposes that if, for instance, in a marriage relationship, there's divorce, you went into joint property ownership. Then, as part of your divorce proceedings and whatever there is around it, you should remember to quash that joint ownership and then determine who will take what and the rest of it. Would that be proper advice to give anybody?
So that is the whole conversation. So what we are saying is that once we have understood the risks associated with
Mm-hmm.
joint tenancy, we look at what ought to be done. And
Okay.
that's why there are two options.
Right.
And let's also remember that when we are going into that property purchase agreement or arrangement, the mortgage advisors, the lenders, and all those people will be, of course, they are involved. And your mortgage advisors will let you know that there are two types of ownership. You and your wife are buying together, but determine separately based on individual advice you seek
Mhm.
what arrangement you want. So you have to agree because you are at this point you are together. And you see, at this point we all come together and say, okay, let's go for joint tenancy. Forgetting that it will be necessary in future to change before anything happens to the other party or to yourself, so to
Mhm.
speak. Now, so with your advisor will tell you complete a form, the ownership arrangement form, as part
Okay.
of the process, the
Mhm.
conveyancing process, and you have to fill the form, sign both of you, and send it. That paper will go to the necessary AP forms that will go to the land registry for the registration of the title of that owner property. And in there will be a restriction, and the restriction will stem from the type of ownership. So the proprietary interest and all those things, there will be information regarding the fact that it's a tenancy, it's a joint tenancy. If it's a joint tenancy, one of the restriction is that once the first dies, the property goes to the
Goes to the other
surviving
person.
person. And so you have to know that if you die first, thinking that you have property, the property will not automatically go to your estate or your family members. It will go to your friend whom you own the property with, or it will go to your neighbor whom you own the property with, or your church member whom you own the property with, or your family member whom you owned the property with. Now, so how do we make sure that these things do not happen? And because we are looking at implications for our will.
Mhm.
So the alternative is the tenancy in common. Tenancy in common means that you own it, but even though you are holding it as one, you have your individual rights
Okay.
separately from each other.
Mhm.
And so whatever percentage you have, in this case, it's not going to be 50-50 or equal share. It's going to be the arrangement that you have in terms of percentage, the percentage ownership that you have agreed from the start of this arrangement. So if you own 90%, your 90% will follow you even after death. If you own 10%, your 10% will follow you after death. And when we say after death, we are saying that after death, it will go to your estate. And depending on whether you left a will, it will be treated under your will or under intestacy, depending on whether you died intestate
Mhm.
or you died with leaving a will. So, how does joint tenancy in common works? With tenancy in common, you own specific percentage as individual joint owners. Everybody's interest or percentage is protected.
Mhm.
And so once there's death, you die with yours and I survive with mine.
Okay.
That is tenancy in common.
In common.
And this arrangement is called severance. Severance. Severance simply means that we own it together, but we are treated severally
Separate. Okay.
in terms of, or separately, in terms of our rights and responsibilities. And the specific right within that property ownership. That specific right will be that for us, it's what happens after death to the property. If you are both alive, you can decide to sell the property and share the proceeds. But after death, what happens to my share of the property? And under tenancy in common, your share of the property will be protected and it goes to your estate as part of your assets. And so if you added that property to your will and indicated that this property I own with my friend, my percentage is 60%, and this 60% should go to my child named A, that will be protected. Regardless of who died first, it is protected. So we are looking at protected interest and unprotected interest in that joint ownership. If it is tenancy in common, it's a protected interest. If it's joint tenancy, it's not a protected interest. So the question will be, now that I have heard this, how do I go back to protect my interest
Protect your interest.
before I die? We are going to go to the government dashboard, .gov dashboard. So producer, please, if you are available, please share the resource with us. We are going to look at how to make changes to the arrangement and if you are going to sell the property and all that.
Yeah, but before we go on, we have had a lot to look at. Joint property ownership is what we're discussing and the implications for our will. Lawyer has given us the scenarios that we can get into. We can have something that is not of the joint property where we own them separately, where we can bequeath that to people in our estate and in our will. What would you do? How are you going to correct what probably you have signed and you did not understand? That's the point we're going to. But before that, let's say thank you to our benefactors, BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors is located on the 4th floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You can call them, book an appointment, and come see them. 0208 493 7340. 0208 493 7340. In emergency situations, you can call 077 127 61884. 077 127 61884. If you're coming to BWF Solicitors by public transport, get on the Victoria Line on the Underground, get off at Seven Sisters Station. Use exit number 2, and it will bring you to the frontage of the Anna House. Climb up to the 4th floor, and they are there. Somebody spoke to me earlier in the week that I found quite interesting. Said I would have to delay a few things so that I can visit them regularly, because when I go there, I enjoy the chocolate, I have a cup of tea, I have hot chocolate, Ghana cocoa, and I'm like, come on, you're just wasting money. Yes, that's what you get when you come to BWF Solicitors. Apart from the professional satisfaction you get from the job they do for you, they also make you feel at home. The Ghanaian welcome is always at BWF Solicitors. BWF Solicitors are trusted partners when it comes to the law. 0208 493 7340. Watch this and take a cue from what they do and how to do it.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, we are back, and we thank you for keeping faith with us and staying along. If you just joined us, we're live on BWTV, on Facebook at BWTV, on YouTube at BWTV, and also live at BWF Solicitors Facebook and YouTube. Our resource person and guest this afternoon is lawyer Charles Asma, and we're looking at joint ownership of property, the implications for our will. He's looked at the two scenarios that we can have, but if we go into a joint property ownership and one person passes on, what the law says is that it goes to the other partner who would own 100% of that. Meanwhile, you may have wished that you left part of that property you own with another person to your family, to a loved one, or somebody you wanted to bequeath that to. You would have gone to that situation. How do you correct that? Whatever it is, there is a way. And that's what BWF Solicitors is helping us. And lawyer Charles Asma is going to take us into that in the next segment of the program. Now, lawyer, yes, you asked us to go to the gov.uk platform where the answer would be. Can we go on to it now and get into the detail?
Sure. Producer, please. So, Bravico, if you can lead in terms of where we are heading. So, the overview, we've already explained the two areas of ownership: joint tenancy, which has no protection of rights of the one who dies first, and tenancy in common, which has protection of the right of each party, and it doesn't really matter who dies first.
Okay.
So
then, if I could quickly glance through the bullet points, we're talking about joint tenants here, and as lawyer has explained, as joint tenants, sometimes called beneficial joint tenants, you have equal rights to the whole property. The property automatically goes to the owners if you die. You cannot pass on your ownership of the property in your will. The other side is tenants in common. As tenants in common, you can own different shares of the property. Your share of the property does not automatically go to the other owners if you die. You can pass on your share of the property in your will. Those have been explained to us. Now, what lawyer was going to get to was the change of the type of ownership you have. With your permission, lawyer, read on.
Yes. So
you can change from being either joint tenants to tenants in common. For example, if you get a divorce or separate and want to leave your share of the property to someone else, tenants in common to joint tenants. For example, if you get married and want to have equal rights to the whole property. There's a line that would excite people. There's no fee to do this. You can also change from sole ownership to tenants in common or joint tenants. For example, if you want to add your partner as a joint owner, this is called transferring of ownership. But let's concentrate on the property that we have made together and changing from joint tenant to tenant in common. Lawyer.
So it says that to change from either of them, you just follow the link. So, for example, joint tenant to tenant in common. Today we have learned that depending on the arrangement, you were with somebody, you are no longer together, or you are with somebody a year later, you realize that, you know what, I have to protect my interest in this property. So I want to move from no protection to protection. So it says follow the link. So you click, and it takes you to a page where you can go through the process. And again, depending, some people also move from protection to no protection, depending on the situation. So if you want to move from protection to no protection, otherwise joint tenancy in common to joint tenants, you can also follow the specific link, and it take you to a page where you fill a form. There's no fee, and this is on government website. So there's no fee. You can also speak to your conveyancer, in other words, the person who helped with the acquisition of that property, or any conveyancer at all, to go through that process for you. What it means is you can do that, or you can hire a service of a professional to do that for you. If you are doing it yourself online, there's no fee. But if you are hiring a professional to do it for you, of course, the professional will go online and do it, but their service, you have to pay for it. So let's bear that in mind. Again, today we didn't discuss situations where you own it alone and you are converting it to joint or tenancy in common. It's also there that you owned it before your partner joined you, or you owned it before you had that friendship and you want to add the person to that. Uh, in this case, you have to move from sole ownership to joint ownership by transferring the ownership interest. In other words, you are dividing 100% to some percentage. All these options are there. Today we didn't, but if you are owning it, if you own it as a sole owner and you are converting it to joint, from today's conversation, I'm sure you would want to consider tenancy in common instead of going joint tenancy and moving again to tenancy in common, because the implication for our estate or will after death is very, very um, uh, severe in that sense. Okay, okay.
Yeah, Lawyer, I wanted to find out to the ordinary person. The document says tenancy. We're talking property here. Does it refer to only property like land, building, going to a mortgage, buying a house, or it could go and cover any asset at all?
Okay, all right. So generally, we are looking at landed properties, be it land that is not developed or immovable property such as a house or a building. So if it's a building, the reason why we say tenancy is to do with asset ownership.
Okay.
It could be, so, we have tenancy and we have lease arrangement and all that. It's to do with landed properties and um, properties such as land, house or buildings and so on and so forth. But somebody will say, what about cars? Cars are assets, but they wouldn't follow the rule of tenancy. Because when you buy a car, I haven't come across joint ownership of a car. There's always the registered keeper of the car.
Okay.
Yeah, there's always a registered keeper. And of course, in terms of who can use it, you can go with multiple drivers, but the ownership will always be one person per se. So it wouldn't follow the car ownership. Again, if you have shuttles, such as gold and jewelries and all those stuff, that would also not go under tenancy because
Okay.
it doesn't follow the principles of landed properties, buildings, and such assets. Somebody will say, "What if I own um, something like a company or a business?"
Mm-hmm.
Is that the same thing? Let's bear in mind that in terms of business ownership, again, there will be registered owners, and the owner, in terms of the shareholders, that will be with company's house. So again, this will not apply to this conversation. And so strictly, this conversation is to them. That is where the risk is. So landed properties, immobile properties such as buildings, houses, those are the things we are referring to. Somebody will say, what if I own a warehouse? Well, a warehouse is a building. So somebody will own the warehouse either as joint owner or owner with tenancy in common.
There's this bit about corporate bodies. You register a company, and the company owns assets. So if I go into a joint ownership of an organization, or we have shares in a firm, it would not fall under this, will it?
Shares do not fall. Shares are called choices in action. They don't
Mhm.
follow this principle. But you mentioned that what if an artificial body, such as a business, jointly owns a property such as land with a natural entity such as a person.
Mhm.
It can also possible that there could be such joint ownership. For example, I'm the owner of my property, of my company or my business. My company is buying assets with me. That could be joint tenancy or tenancy in common.
Mhm.
But mind you, the business will never die because the business follows what we call a going concern principle.
Mhm.
Businesses do not die. And so, if a business is owning such assets with a human being, then obviously they prefer that the best option would be tenancy in common if there's going to be that arrangement. Because
Okay.
why will you fight with somebody or something that is never going to die?
Yeah.
You will die first. In this case, you go for tenancy in common so that yours can be protected and the business interest will be with the business.
I'm going into a property ownership with another person. We go to the conveyancer or the mortgage advisor. They give us the various documents to complete. Um, is it one of the mandatory steps and forms to complete to tell us that we should choose either tenancy in common or joint ownership?
Yes, so as part of the advice, the conveyancer or the mortgage advisor, well, it's not even the mortgage because the mortgage is mainly to do with
With the financing.
getting getting the financing arrangement.
Mhm.
But with the asset itself, it will be the conveyancer, the property solicitor. And the property lawyer, as part of the advice, will have to point it out to you to specify how your ownership should be specified. And you fill a form. So they have to send you a form as part of the land registration forms. And you have to specify so that on the land's profile, or when we go to land registry to check the title of that property, all the information such as the proprietary um, details and the property details, the restrictions, the type of ownership, all this will be there. So under the type of ownership or the proprietary details, we'll have whether it will indicate whether it's a sole ownership, joint ownership, or tenancy in common. And then, of course, restrictions will come or will follow. And the lawyer will have to point this out to you, and you have to make your own decision. You fill the form, and the form will be part of the registration process to get the land or the property registered.
Every law, every act that protects the rights and responsibilities of citizens operate in a jurisdiction. Are we just talking about what happens here in the UK, or other countries may have their own ways of dealing with these?
So earlier on, I mentioned that when it comes to ownership of property, it doesn't really matter where the property is and who owns it. It's the property in question and the individuals who are sharing or buying it together. So whether in Europe, in Americas, in Africa, in Asia, in Australia, it doesn't really matter. They follow the same principle. Of course, this is what we call equitable provisions within rules, or in terms of land, it follows the land principles, land acquisition principles. So we are not just looking at UK, but every country. But when it comes to the will and intestacy arrangement as to what happens to your asset, the way the asset will be dealt with, depending on whether it's under intestacy or under the will be different depending on the countries involved. In some countries, there are strict rules for intestacy. In some countries, the rules are codified and so on and so forth. But because we are not discussing will and intestacy today, we only mentioned that when you are buying, and especially now, especially in the UK, and I think everywhere in the world, individuals are encouraged to go into joint ownership of property so that they can climb up the property ladder to start with and later decide to own individually or solely because of the cost involved and all that. Imagine buying a property that costs, let's say, 200,000, and you are buying with your friend or with a family member. So you are sharing the deposit cost. So it's easier, or you are owning it with a housing association. And that is where your question comes in. That is it possible to own with an artificial entity? Yes. So you can have a housing association selling a property, or a developer selling a property and telling you that this property goes under joint ownership arrangement. And so you can buy half of it and the estate developer owns half. That means you are competing or you are owning with an artificial entity. And so in this case, it is better to go for tenancy in common because you are going to own a property with an entity that will never die. And mind you, housing association or the property estate developer or the property developers, they are artificial bodies because they are registered organizations.
Mhm.
You are not dealing with the individuals in there, but you are dealing with the organization. So another learning for us today is that if you are buying um, part ownership of a property with a property developer or housing association, please bear in mind that your best option will be tenancy in common, because you are the human being here with expiry date.
Well, if they ask you to buy a percentage of the uh, ownership of a property, lawyers just advise the best option is to not go into joint ownership, but tenancy in common. So, whatever you have paid and invested in the property will be yours even when you are no more. We're live on BWTV. We discussing joint property ownership, the implications for our will, and we've looked at what would be of benefit to you. If you didn't know, now you know. There are ways of correcting it if you'd want to change your mind from joint ownership to property in common. And lawyer has given us that link and the document if we want to have it again and check what it is, that you can go onto the .gov.uk website and then click on that link. And if you want to change, there is a link for you to do that. If you're doing that yourself, it's all free of charge. But if you want to hire a professional who really understands the situation and will help you do that, it may be a fee charge. So, Mr. President, let's see if we can just do that click quickly and come back and get your questions put to Lawyer Charles Asma. There have been some very interesting discussions on the platform, and we'll be throwing them out there for Lawyer to help us. Yes. So if you want to
So,
change from joint tenants to tenants in common, let's see what the link will give us. Yes, this is called severance of joint tenancy. You should apply for a Form A restriction. You can make this change without the owner's agreement. The solicitor, conveyancer, or legal executive can help you check what type of joint ownership you have if you are not sure. How to apply if the owners do not agree to the change. Serve a written notice to the change on the other owners. A conveyancer can help you do this. Or you can download and fill Form SEV to register a restriction without the other owner's agreement. You can also fill Form X1 to register Form A restriction if you cannot provide any of the evidence of severance. What I would advise strictly and more sincerely is that get a solicitor or a lawyer or a conveyancer to do that for you, because there may be some little complications that you may not be so conversant with and confident about. Let them do it for you. I've always said, and I'll repeat, that it's always best for a layman to give his work for an artisan to do for him or her. We take this short break, and when we come back, we take your comments, your questions, and your contributions. Lawyer Charles Asma is our resource person. We're doing this courtesy BWF Solicitors. Call them 0208 493 7340.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. Earlier on, I mentioned and I read something about leave to remain here in the UK and the um, right for dependents of students to work. Under paragraph ST 39.1 and ST 39.3 A and BI or II of Appendix Student um, into the immigration rules, a dependent partner will be granted permission which ends on the same date as the student's permission. The dependent will have no access to public funds and where the visa was granted for a period of less than 9 months, or the student is studying a course below degree level, there will be no right to work. Working in breach of your leave condition as a student dependent is an immigration offense. So then I asked this question about our friend Grace, who was granted leave to enter the UK as a dependent of Johnson from the 30th of September 2024 to the 31st of July 2025. Johnson, we're referring to here, is a student. He has valid leave from the 2nd of February 2024 to the 31st of July 2025. The dependent Grace arrived in November 2024. On the 8th of May 2025, Grace was arrested by the Border Force whilst working in a warehouse. Her leave was cancelled without an appeal, and she was detained for deportation on the 29th of May 2025. Now, the Border Force claims that she breached her visa conditions and committed an offense under Section 24(1) of the Immigration Act of 1971 as amended. So I'm asking you to help me give a piece of advice to our friend Grace. Grace, well, we can say you have no right to remain in the UK because you were caught working in breach of your visa. Or we can also say, Grace, you cannot be removed as your spouse still has a valid leave in the UK, which is number 2. Or we can also say, well, Grace, go and seek for judicial review as you have not breached your visa conditions by working. Which of the 3 answers would you pick as a piece of advice to Grace? Well, with that, let's come back to our discussion and speak to Lawyer Charles Asma again. At this point in time, the lines are active: 0208-493-7345, or you can send a text, WhatsApp, and an audio message to 0739920848, or you leave your questions and comments in the comment section down below, either on Facebook at BWF Solicitors, YouTube at BWF Solicitors, Facebook at BWTV UK, and YouTube at BWTV UK as well. Lasma, thank you for sticking around. Now, my next question before we bring in any other comments is this. We've talked about one of the joint owners passing on. In joint ownership of a property, yes, then the full ownership goes to the other person that's surviving. But there could be a situation where even before one person passes on or dies, they would want to sell the property. What happens?
Thank you. So there will be a restriction on the property papers, what we call the land title, under the part called restrictions. Producer, if you're available, please help us with the resource in terms of selling the property, which is under joint ownership. So the link again, if you can share the same resource.
Yeah, the .gov.uk.
.gov,
link.
yes.
Yeah.
So yeah, Bragoku, sell the property if the other has lost mental capacity. So here, of course, if you are both alive and you are both sound, fine. You decide how to sell it. You don't really need to do any special thing other than going through the process to sell the property, so that you can get your equities from it and pay off the mortgage or the loan. But what if the other party has lost mental capacity and they are not able to agree with you to sell the property, how much to sell the property, and even how to instruct a seller or a buyer? Yes, what do you do? So the law is clear on what to do if one of the joint owners has suffered mental capacity.
So then this one is saying that you'd have to apply to the court of protection if you want to sell the property, but the other owner has lost mental capacity. Now, if we say mental capacity, lawyer, are we looking at somebody who is grown so old that they can't make decisions on their own, or they are suffering some form of incapacity where they can make decisions on their own. Is that a situation or those situations we are looking at?
Well, people are old, and therefore age does not affect mental capacity. Of course,
Mm,
some age and other factors will affect mental capacity. And so it's more of those other factors other than just age. Those
mhm,
factors will be that they have suffered some illness, such as dementia, and they are not able to process thought to be able to make informed decisions. In this case, what do you do? Or people have suffered extreme mental handicap breakdown, and that has affected their thought process. And so they are not able to make decisions under the Mental Health Capacity Act and those other legal provisions. In this case, you cannot say that we are selling it while the person didn't even know that there was going to be a sale.
mm,
So who makes the decision if we own it together? In this case, you cannot say that, well, if you can't decide, I will let your brother or sister or a family member decide for you and the person will do on your behalf. No. You need to go to the court of protection to protect that person's interest. And the court will look at what to do to ensure that that person's interest is protected in terms of the decision to sell the property. So the learning here is that whilst you are both alive, if you decide to sell, if there is the need to sell the property, but you cannot agree because the other party cannot make a decision themselves, then you have to apply to the court of protection, which is again via the online platform, or you can seek legal advice on that. Then you go through the process to have the agreement from the other party so that you can sell the property.
So yes, there are situations where you will not find yourself so locked that you can't do anything. There's very interesting comments on the platform, lawyer. Let me pick one from uh, Daniela. Daniela starts with one that says, that's why when they start killing each other in the name of survivorship, it's a bit of, well, you're laughing out loud, Daniela, but that's a serious and difficult situation, and that's the more reason why we having this program. Then so you know what to do, and you don't fall into a situation where you would say, "I did not know." That may get you to do all these silly things, but we don't encourage that. That is not the idea for which we're doing this program. We want you to be so enlightened that you make the right decisions for yourself. Same Daniela comes up with another one. It says common tenancy and joint tenancy. That's what you want to mean. Common tenancy is a protected tenant, and their estate can be passed on to their loved ones. Um, I think that's what lawyer has gone on to explain. But Daniela, however, says that um, joint tenancy does not offer protection through a will, and in the event of death, full ownership uh, automatically transfers to the surviving joint tenant through the right of survivorship. Yes, as I think he came on when lawyer was explaining all those ones, and Daniela continues to say that please advise us, lawyer. I know someone who recently passed but had money in the savings account towards his mortgage, but sadly he passed without anything in place, and now the family has lost his money to the bank and the government. What would they, or what do they have to do in this situation?
So, Braco, this is common. This is very, very common. Um, it could be you, could be me, could be Daniela, could be everybody or anybody at all.
Mm,
Most of us, or everybody has a bank account, but our families may not know even the details of that account. And you may not even have mentioned it in your will because you died intestate.
mhm,
And so nobody knows that you have an account with Barclays or with HSBC or any other bank for that matter. Nobody even knows that you have some other things. And so this is a very difficult thing, actually, Daniela. I agree with you. But what do? What we would say is that if you have a bank account, share the details with your family. Let them know that you have this account with this bank. In your in the event that you are not alive, family will go to the bank with evidence that you are a family member to let them know that this is their family member. He, as part of his assets, we are putting them together to look at the estate in general.
Laura, there are issues of trust, you know. Sometimes people think that when I disclose these things or I reveal these things to people, well, there could be some fraudulent issues here, you know.
But yeah, I mean, you don't have to tell the person the account details per se and the content of it. But
Mm,
saying that I have an account with this particular bank or I have four accounts with these at these places, or better still, if you are going to prepare your will, you indicate those things or those account in your will. But you see, the thing is that most of us have not made our wills, and we
mm.
don't know when we are going to make those wills. With the best intention that you will put a will together, you don't know, and death follows us every day. Could be today, could be tomorrow, but the most important thing is that if you are going to leave your will, you have to indicate in the will. But if you haven't left a will and you didn't trust anybody, so you didn't tell anybody, then the rules will apply that because nobody knows. You see, the question is, I mean, Daniela, how did you even know? Or how did the family even know that this person holds account with this bank?
Mm.
They will only assume that, oh, this our friend once mentioned that, or our brother once mentioned that he is going to buy a property and he's saving. We know he's saving, but which bank they don't know. But if they know he's saving and they know that he has account at a particular place and they have evidence to show that he's a family member, a child or a grandchild or a parent in terms of birth certificate and family records, then they can of course go to the bank and but in terms of the process, I mean, I've seen Daniela mention probate, but Daniela, your question wasn't about how to. Your question is about why is it that some people die and the bank takes over their savings or their money in their account. It happens because nobody knows that they have that account money in that account, although nobody knows about it at all. And when nobody knows about it, once you die, the bank, of course, every some banks do it every 6 months, some do it every year, but they do what we call review on accounts. So if an account has been left dormant for about 5 years and they cannot have anybody coming forward, no access to it, then of course, after some time, it will pass to the state. It doesn't go to the bank, it goes to the government. But if the family knows that this person owns this bank account or holds this bank account, then once the person is passed, they go through the process as part of the administration of that person's estate. And of course, probate will come in. And this is where we also mentioned that BWF solicitors, one of our practice areas is probate service. We do wills as well. So with probate service, somebody who has died and the person the family or the people left behind are putting together the estate of the person and they want to access all the necessary get hold of all the assets, then of course the will come in. But again, as part of the probate service, we will be able to support you to apply for the letter of probate from the probate service or probate registrar, and from there you have the power, depending on who is named in the will as the administrator or administratrix. If there's nobody named, then of course we'll be able to support you to go through the process. If the savings account is with a bank or building society or post office, we'll be able to get through that. If assets are located everywhere, we'll be able to go through that. Of course, if assets is under tenancy in common, we'll be able to have it as part of the person's estate and help you so that your estate will go to the right people that you intend them to have.
Yes, keep them coming through. Your text will come to 07399208468, or you can call in on 0208 493 7345. M&S Venture says, I hope you're okay. Yes, we are. Thank you very much. God richly bless you. My brother did apply for indefinite leave to remain. His children have come, but his children's own or the application has come through and they've had a response, but his has not come. He has already written the life in the UK test and gone ahead to do the B1 in addition. So, Eminest Ventures, I think your question will be, what can he do? Does he have to wait? Does he have to write to them? What can he do, lawyer?
Well, I don't. Well, the question is that my brother applied for indefinite remain. Is it with his children? His
Yeah,
children.
it says his children own have come, but his own has not come.
Oh,
Yeah.
and yeah. So the B1 and all those things are really not part of the question. Of course, you needed a B1 to be able to um, apply for the indefinite. So
Mhm.
the whole question is that application has delayed. What do I do? Chase it. Chase it.
That no, if you say chase it, how does he go about chasing it? What kind of letter does he write? Who does he speak to? Who does he chase it with?
So if this was done through a lawyer, the lawyer will follow it up.
Okay.
Either you do a letter of complaint to say that it has delayed unreasonably, and if it's unreasonable delay, how many months are we looking at here? So you have to look whether it's beyond the standard time. We know the standard time is minimum of 6 months. So if you've gone past 8 months, then that is serious delay. You can ask for, you can make a complaint. 1 year, you can make a complaint. But our friend did not tell us how long this has delayed for. If it turns out to be 3 months, because the children were successful or lucky to have theirs in 2 months, and yours has been 3 months, then it doesn't mean it's overly delayed. But if it's overly delayed, say 7 months, 8 months, a year, then you do a complaint. You can send it by email, or you can send it by post to appropriate address. What you do is that you go online and search letter of complaint for application delay. You get contact details, emails, and address. Then you send it to that place. Or you can also send a pre-action protocol letter to say that it's delayed unreasonably and beyond the standard time, and it's affecting the needs of the person, and there's intention to take legal action, excuse me, i.e., judicial review. And so they have to take steps to mitigate that. Then, of course, you are sending a pre action protocol letter, again by email or by post. You get the details once you have searched. But if a lawyer did it for you, then the lawyer knows what to do to be able to chase.
Yes, and I would want to reiterate the advice I always give that give your work to BWF solicitors to do for you when it comes to all these legal matters, especially with immigration matters. BWF solicitors, you can contact them on 0208 493 7340 or in Ghana 055 589 and in emergency situations 077 Daniela says the guy started talking to a state broker and he had printed his bank statement. Well, I think the answer and the explanation has gone on for you. If you need any further discussion on this matter, you can contact Lawyer Charles Asma directly or um, contact BWF solicitors on 0208 493 7340. As I said, Ole Asma, you can call him on 07947 6360 37. I think there was a text on there. Shall we pick it up on again? Could you Boateng, a 64-year-old pensioner in Ghana, wants to visit his son in the UK. He supports his wife's business in Ghana, so the wife pays him every 2 weeks from the business account to his savings. Um, so take, retire, or work. Oh, okay. So you're asking whether on the form he should take whether he's working or retired. Laura, would you prefer any advice on for this one, please?
Well, if the person is working because they are getting a wage, then it's obvious, isn't it? Because a pensioner is a pensioner, and a worker is a worker. Because he says, please, he support his wife business in Ghana, so the wife pays him. Is it a regular employment arrangement or allowance for helping out? If it's allowance for helping around, then that would not be uh, employment. So in this case,
Mm.
the person will not be a worker, will be a retiree. So it depends on the context of the arrangement between himself and the wife's business.
We're live on Facebook and YouTube at BWF Solicitors and at BWTV UK. Keep them coming through. In the next moment, we will be going back to our quiz question and then try to see what answers you give me. Can a skilled worker, carer, open a business, or is dependent open a business like a barber shop?
Well, I mean, a skilled worker, you are already busy working, doing full-time job. So I suppose you already. But the question is, can I open a business? There is no restriction on opening a business, but whether you'll be able to run the business successfully is another thing. But
Mm.
there's no restriction.
Okay. Well, if you want to contact BWF solicitors, I've given you the numbers. I want to repeat them: 0208-493-7340. So you want advice on adoption, family matters, immigration, civil litigation, all the other ones. 9:30 to 6 p.m. Visit BWF solicitors. Seven Sisters Underground Station, exit number 2. Seven Sisters Overground Station from Liverpool Street. Uh, get to Tottenham, South Tottenham Station. All the details there. Sandra, thank you very much for providing. Laura, I've been in the UK for 8 months now on a spousal visa. I want to know if my new husband, okay, can bring my children who are not his children if I have a custody order.
Custody, thank you. Custody order is not evidence of single parental responsibility. Single parental responsibility is what we call sole responsibility. And I suppose because this is special, that will fall under Appendix FM rules, especially paragraph 297 of Appendix FM. 297A, we have 297I, we have A, B up to F. A is clear that if the other party or parent is dead, then the surviving parent assumes sole responsibility. But if the person has custody order, it means that there is misunderstanding and the children are living with her. But if the children were living with you before you left, who are the children now living with? That means the children are not suffering after all. So if the children are not suffering, of course, so custody order doesn't also take away the responsibility right of the father. In this case, I think this is a woman. So the responsibility right of the father is there or intact. So you cannot make a decision to relocate the children because you are married and you want the children to live with you and their stepfather. And again, so the main thing is whether having remarried and the children living with you, the man, which is the father of the children, does not play any role in the life of the children. And here, under sole responsibility, the rules say that you have the full direction and control regarding the welfare, the well being, and development of the child in terms of every decision that pertains to that aspect of the child's life. So, decision about school, decision about religion or church or mosque, decision about healthcare, decision about friends the child has, decision about who is looking after the child, and so many other things. And the question is, since you came 8 months ago, have you sought to visit the child? If you claim that there's nobody else, if there's somebody else doing the job for you, then why do you rush to relocate the child? And so if sole responsibility is not possible because the other parent has a right, then you have to look at the other aspect, which is F. F says that if there's serious and compelling family circumstance making the exclusion of the child from the UK undesirable, simply means that if you leave the child where they are, something can happen to them and to affect their life, then you can relocate the child. But you have to prove that something is affecting the life of that child. So your question is, can I rely on sole custody as a piece of paper or document to relocate my children? No.
Well, keep them coming through. Thank you very much for your time. Thank you very much for sticking around. But then I am going to the segment where I would want your answers to the scenario I posed to you. Grace was granted leave to enter the UK as Johnson's dependent from the 30th of September 2024 to the 31st of July 2025. Johnson, a student, has valid leave from the 2nd of February 2024 to the 31st of July 2025. Grace arrived in the UK in November 2024. Now, on the 8th of May, Grace was arrested by the Border Force Agency while working in a warehouse. Her leave was cancelled without appeal and she was detained for deportation on the 29th of May 2025. Border Force claims she breached her visa conditions and committed an offense under Section 24(1) of the Immigration Act of 1971 as amended. So, um, this situation is brought to you. What advice would you give to Grace? Would it be one, Grace has no right to remain in the UK because she was caught working in breach of her visa? Would it be that Grace cannot be removed as number two, as a spouse still has a valid leave in the UK? Or three, Grace should seek judicial review as she has not breached her visa conditions by working. After this short break to announce our social media platforms, we'll come back and pick up your answers. Welcome back and thank you for sticking around. Yes, I'm waiting for your answers. So let's see what you have. Daniela says it's number three. Grace should seek judicial review as she has not breached her visa conditions by working. Thank you, Grace, for that. Abigail Bachi says it's number one. She has no right to remain in the UK because she was caught working in breach of her visa. And next we have William Ajimai thinking that is number two. Grace cannot be removed as a spouse, still has leave, valid leave, so to speak, in the UK. Justice Boating thinks is number two as well. Grace cannot be removed as a spouse, still has valid leave in the UK. Albert Osafo thinks Grace has no right to remain in the UK because she was caught working in breach of her visa. Same for Lydia Opon, who also thinks that Grace has no right to remain in the UK because she was caught working in breach of her visa. Diana Ponsem agrees. Grace has no right to remain in the UK. Adem Mununkum also agrees. Grace has no right to remain in the UK. And Adem Mununkum says number three, sorry. Grace should seek judicial review as she has not breached her visa conditions by working. Collins Adolfo thinks it's number three as well. Grace should seek judicial review as she has not breached her visa conditions. Stephen Dapa thinks so as well. Interestingly, somebody's come on my line. Let's see if the person is going to give me an answer. Hello. Yes, sir.
Good evening.
Good evening.
Lawyers, no good evening. Really, the matinee you are move on my phone.
Yeah, see that's it.
We a quick question. Maybe we put a question here. Sorry to be very late. None of you, mama.
No problem. But in time, let me say your time in the area.
Never to remember. But the question is, my sister, while wearing this chroma cancer, no for immigration purpose, just married. And I want to about Montana active. So much security, I'm a cancer number down Kufu for so. However, no share Bema Kufu for so, and one now. One in the way, no, or naive about the UK law, and on my biological father and the Yakoto Afana, so say, and I'm improved, and I told you also within that. And I bear man now, our moon tremuno. On this side, I'm not to say, on the banner, it's over say, on the go to see, I put an opinion, issue and empty.
Only no. Our first one, no. Why your proper divorce?
But only for a separation, a separation, and I can't remember then to kind of bomb.
There's a divorcee. Until legally, no, or you're married to the Nippon and separated.
That's right.
Okay. To which our brother is saying that there's a lady who is married to a gentleman here in the UK. They are separated, they're not divorced. Because of the situation they found themselves in, the council has given the lady accommodation in another place, and where she has met another person and has had a baby for the other person. Now, there's confusion as to who should put the name on the birth certificate. The biological father says that it's me, that's my child. And the person that is legally married says that, no, the law says that that is my child. Lawyer, where do you stand?
Thank you very much. So we look at section 50, subsection 9, capital A of the Nationality Act. And also we look at aspect of the Children Act. We are looking at who is the father of this child. Is it the man who is in the marriage or the man who impregnated the woman? Because the marriage has not ended, even though they are living apart, there's no divorce in place. The child father is the man who is in the marriage which has not dissolved yet. And so it's not the one who impregnated her, but the one whom she is still married to.
So in this case, I think if I got my friend right, the biological father has had his name on the birth certificate. Is that wrong?
So because they didn't know, that's why they did that, thinking that because the biological father impregnated the lady, he is the father biologically. But the law is that he's not the father. And so now there's contention. So they have to, of course, the one who is claiming fatherhood of the child can go apply to the registrar to have the certificate amended. If there's contention, the court will resolve. But it's a clear situation that the court will conclude that the father is the one who is still in the marriage, because the marriage was not, or there was no divorce before the child was born. So it's a mistake that a wrong father's name was put on the birth certificate.
What's the answer, lawyer?
No, my chat here, but said legally now under our reality, but the purpose that not DNA.
No, but the law says that the rightful father is the person who is legally married to the woman.
Okay. If lawyer says, so what is the consequence?
If they go to court, the court will rule, and whoever is not the rightful father would have the name taken away from the birth certificate.
Okay. Because let me read some. I can't say back of the school for dean now. The divorce school to the not.
Said divorce ni nyamai. She has not done the divorce. Omun divorce inti. So omun divorce that's a different issue. But omun divorce. Until whilst the person or the two people are legally married, the father is the husband, who on records is the husband.
Okay, it's the last the consequence then Obama not many other things and then the consequence then work for Obama. So
Mistake no, yeah, it will be corrected by law.
Okay.
Hmm.
Okay. Okay.
Okay. Matthias. Okay. Okay. I think. Thank you very much. God bless you. Daniela says it's number 3. Well, on our quiz, when our brother came in with this question, Grace should seek judicial review as she has not breached her visa conditions by working. Yeah. I've got people choosing all the 3. Which one is correct?
It's interesting. It's good. We have variety of understanding of the question. So we look at paragraph ST 31 1B of Appendix Student, which says that if a student is granted a visa more than 9 months for a full-time course, especially postgraduate course, that is the starting point. Then we look at ST 39, which also deals with the fact that the dependent will be granted based on the student visa. We are told that Grace was granted from September. What it means is that she applied after the husband has started the course or arrived in the UK. So if you count from September when Grace was granted or received her visa, it was 30th of September. So you start from October and give and take by 31st of July, that would have been 10 months, right? 10 months. Now, again, the student was granted from February, expiring the following year, July, which is more than 1 year. So the student was granted for more than 1 year full-time course. Much as the student cannot work full-time during term time, only 20 hours, the dependent is not restricted because Grace's visa, or because Johnson's visa was for full-time study and was more than 9 months. Grace was also granted more than 9 months. Yes, at the time Grace was caught working, she had less than 9 months for the visa to expire. But it doesn't say that when you have less than 9 months, you have to stop working as a dependent. It says that if the student was granted less than 9 months and Grace was granted up to that less than 9 months, then she couldn't have been working. That would have been unlawful on her part. But what she was doing was not against the law. And because they canceled the visa and also added that there is no right of appeal and the removal direction was set, Grace can only seek judicial review to deal with the matter. What I want to point out is that I want to also say that this is what we do at BWF Solicitors. This is a live case. So this is a client. The name is different, but this is a live case. The person, the lady, was actually required to leave the UK 29th of May. And the person she was arrested on the 7th, contacted us on the 13th, while she had been in detention for about 5 days. So she contacted us, through family member, this is the situation. So we intervened. And the first thing we did was to stop the removal direction set for 29th, arguing that there's no mistake on her part to be working because the rules are clear, and we pointed it out. And because she has not been given right of appeal, that decision to deny her right of appeal is unlawful. And so we are seeking judicial review. And we told them that we are seeking a review of the matter, and so they have to release her on bail while the court is looking into that. And I'm glad to say that this client of ours was released last week, and we are still looking at the final decision from the court.
Well, as I said, you always have to trust BWF solicitors to do that. Let's mention that Grace's leave to enter was based on Johnson's visa as a full-time student. And when I was reading the question, I asked you to look at particular dates. You realize that the leave was from 2nd of February to the 31st of July, which is more than a year. So the caveat doesn't really affect grace, as it were. So if the border agency said that, yes, you had no right to remain in the UK because you were caught working in breach of your visa, she had not breached her visa. So obviously, you'd seek judicial review, as obviously she had not breached the working conditions. The decision to cancel that would be challenged. And as well as said, is a live case and is being challenged, and we're waiting for the outcome. I know definitely when the positive outcome is had, we'll share that with our viewers as well. And with that, we come to the end of another edition of the Community and the Law. And I'm going to ask lawyer Charles Asma to sum up what we discussed for us as part of our tradition. Lawyer.
Thank you very much. So today we have looked at buying or owning property together, especially where people are not able to afford a loan and they need helpers to team up to be able to own together. You own with an individual, or you own with a company, housing association, or state developer. Regardless of who you own the property with, there are two rights. Either you own as joint, or that joint tenancy, or you own as tenants who have common rights. Common rights simply means that even though we are owning it together, our rights are separate and protected depending on the agreement of percentage. And that joint tenancy, we say that we are owning it together, our rights are the same, our shares are the same, but we own it together up to the point one dies, and the one who survives owns it fully. And because of that, under joint tenancy, the one who dies first cannot pass it to their will. If they pass it to the will, it will not work because it's survivorship rule and it will not survive. Now, the best thing is to have gone for joint tenancy. Tenancy in common is to have gone for tenancy in common. And so we have concluded that where people have owned property together and it is tenancy in common, regardless of who dies first, the rights are protected, and so their share of the property will go towards their estate when they are dead. And in this case, if you have already bought a property and you now know that you should have opted for tenancy in common and you want to change, you can do that. The rules allow you to change by going online. We share the link. So if in case you are not sure, just google.gov.uk joint tenancy or joint ownership of property. You see the information, but we are not encouraging you to do this without seeking advice. So please seek independent advice if you ever wish to change from one type of ownership to another, which will allow you to have no adverse implication for your will. This is the conversation we've had for today, and it is important to anybody who intends to buy a property with another person, or anybody who has already bought a property with another person, be it family member or friend or whoever. Check if it is joint tenancy. Note that the risk is if you die first, you lose everything. Your family will not get anything. Otherwise, you have to convert it to tenancy in common so that your family's interest after your death in that property can be protected.
Protect your property and protect the things you have acquired together with people, and also protect the wishes you have. Lawyer Charles Asma, thank you very much for your kind time spent with us, and of course, to BWF Solicitors for allowing us to have this platform to educate and empower the community. Yes, Uncle Charles.
Before you go, I think there was a question from Daniela regarding leasing and rent of a warehouse or property. We do not one of our practice does not cover conveyancing or leases and properties and all that. And so we'll not be able to advise on that. We'll suggest to Daniela that she should get a conveyancer or property solicitor to assist her in going through the lease arrangement.
Well, you see how kind Lawyer Charles Asma and BWF Solicitors folks are. We had run out of time and wanted to skip that, but he brought it back and answered you. That's professionalism. Thank you very much once again. So to all our BWF Solicitors family members and to Sandra Fraser, once again, congratulations for being the employee of the month of May 2025. And to you out there, thank you for spending time with us, allowing us to come into your home and into your space to make sure that things are done right for you and also empower you with the legal knowledge. We'll be coming back again same time next week to give you another edition. So get ready and let people know. For now, I know you would have liked the page, subscribed to the channel, and you shared the program today. If you missed the live one, it's still on there, and you can go back to watch it at BWF Solicitors on Facebook and YouTube, at BWTV UK on Facebook and YouTube. My producer has been Professor Ade, Pablo Dodu, and Shilankra. Did the aesthetics and the art. My name is Ulrich Frimpong. Good evening.